Well, gentlemen, you of course realize that the filing of the SAN is governed by the implementing rules and regulations of the Civil Service Commission. Have any of you gentlemen taken the trouble to inquire from the CSC when should ownership be transferred or deemed to have been transferred with respect to a condominium unit?
I'm afraid, Your Honor, that our inquiry into the matter is inconclusive. I am guided, however, by your statements yesterday that we should first have been motivated by honesty. As pointed out by Senator Lacson, the Chief Justice honestly declared this condominium unit in 2010 as testified by Mr. Lim after it was accepted in 2009 by Mrs. Corona. And Mr. Lim further testified that the acceptance was information given to him by the builder or the seller. So we consider that as an admission on the part of the condominium builder or seller that the transfer, the complete transfer of ownership and the free, intelligent, and voluntary acceptance of possession occurred on August 12, 2009, regardless of the provisions on deemed acceptance and the issuance of title in 2004.
Your Honor, for the part of the prosecution, our inquiry with the Civil Service Commission, they informed us, Your Honor, that the SALN form itself, as well as the provision of the Constitution, the Anti-Graft and Corrupt Practices Act, as well as Republic Act 6713, clearly states that whenever an asset, Your Honor, is acquired, it must be stated. And as duly noted by the presiding officer yesterday, Your Honor, when payments were made in 2003 and in 2004 for this particular unit, an asset should have been declared by the respondent, Your Honor, because asset it has an accepted meaning, Your Honor, and no quibbling on the meaning of asset should be debated upon, Your Honor. An asset, when you take out the cash from your pocket, then you get an asset. And this is what we are trying to point out. Acceptance of the unit, Your Honor, is of no moment because in 2003 as well as in 2004, an asset was acquired by the respondent already, Your Honor.
Your Honor, just very briefly, supposing the condominium had never come to be, would that 3-point-something million still be an asset? It would have become a liability.
It is, Your Honor.
If that condominium unit never came to existence and no delivery was had, it could not possibly have become an asset.
Not a liability, it would be a receivable.
Receivable.